If you're a naturalized U.S. citizen, there's something happening right now that you genuinely need to understand, even if you personally have done absolutely nothing wrong and have nothing to hide. The Department of Justice just announced it is moving to strip citizenship from 17 more people across the country. And while this particular announcement involves serious criminal allegations, it's actually part of a much bigger, historically unprecedented pattern that every naturalized citizen should be aware of. Welcome back to U.S. Visa News Hub. I am Mr. Burhan, and today we're going to walk through exactly what happened, what the law actually says, and why the scale of this enforcement effort has changed so dramatically in the last year and a half. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. Let's start with what actually happened. In June 2026, the Department of Justice, working in coordination with U.S. Citizenship and Immigration Services, filed civil denaturalization complaints in federal district courts across multiple states against 17 naturalized U.S. citizens. These filings weren't concentrated in one city or one court. They were spread across the country, filed by different U.S. attorneys' offices in different districts, all within roughly the same window of time. The individuals targeted range in age from 39 to 69, and they come from a wide range of countries of origin, including Cuba, Colombia, Haiti, Mexico, India, Somalia, the People's Republic of China, and the Philippines. This wasn't a coordinated group of people who knew each other or were connected in any way. These are 17 separate, unrelated cases that happened to be announced together as part of a single DOJ press release. The underlying allegations vary quite a bit from case to case, but they generally fall into a handful of recurring categories. Some involve concealing serious crimes committed before naturalization, including, in at least one case, sexual abuse of a minor that allegedly continued even during the period the person was going through the naturalization process itself. Others involve using false identities to obtain immigration benefits in the first place, essentially building an entire immigration history on top of a fabricated identity. Still others involve wire and bank fraud, money laundering, and in one case, distributing prescription drugs wholesale without a proper license. In announcing these filings, Acting Attorney General Todd Blanche stated that the department maintains what he described as a zero-tolerance policy for abuse of the naturalization process, specifically calling out drug dealers, sexual predators, and fraudsters who, in his words, lied about their past crimes. DHS Secretary Markwayne Mullin echoed that sentiment, framing citizenship as a privilege that must be earned honestly, and stating that naturalized citizens who break U.S. laws or lie during immigration proceedings forfeit that privilege. Now here's the legal foundation underneath all of this, because it's important to understand that this authority isn't new. What's new is how aggressively it's being used. Under the Immigration and Nationality Act, a naturalized citizen's citizenship can be revoked and their certificate of naturalization formally cancelled if a federal court determines that the naturalization was illegally procured or that it was procured through concealment of a material fact or through willful misrepresentation. This legal tool has technically existed for decades. Historically, though, it was used extremely sparingly, reserved almost exclusively for the most extreme and clear-cut cases. Things like war criminals or individuals who had committed atrocities and then hidden that history to slip into the country and eventually naturalize. To really understand the scale of what's changed, let's look at the actual numbers, because they tell a striking story on their own. From 1990 through 2017, nearly 3 full decades, the U.S. government filed an average of only about 11 denaturalization cases per year, nationwide, across the entire country. During that same period, roughly 644,000 immigrants became U.S. citizens every single year. So we're talking about a tool that was used in a tiny, tiny fraction of cases, genuinely reserved for the most serious and clear-cut situations. That has changed substantially since the current administration issued a directive in June 2025. A memo from the Assistant Attorney General of the Civil Division instructing DOJ attorneys to, in the government's own language, prioritize and maximally pursue denaturalization proceedings in all cases permitted by law and supported by the evidence. Since that directive went out, independent organizations that track federal court filings have documented a real, measurable jump in denaturalization lawsuits, with a particularly sharp increase specifically in May and June of 2026. Reporting has also indicated that this batch of 17 cases isn't the first wave under this administration. It follows dozens of earlier denaturalization filings brought since early 2025, and this specific announcement itself came almost exactly 1 month after a previous batch targeting around a dozen individuals. In other words, this is very clearly not a one-time event. It's an ongoing, expanding enforcement campaign, and this is simply the latest chapter in it. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. Now here's the part that every naturalized citizen watching this video should pay very close attention to, regardless of whether you think any of this could possibly apply to you. There is no statute of limitations on civil denaturalization actions. None. That means the federal government can file a case years, even decades after someone originally naturalized, based entirely on conduct that occurred long before their citizenship interview ever took place. This is a genuinely important legal detail, because it means that simply having naturalized a long time ago and having lived as a citizen without incident for years or even decades since does not by itself provide any protection if the underlying naturalization process itself involved concealment or misrepresentation. One pattern that keeps showing up in recent cases involves individuals who completed a criminal sentence years earlier, sometimes a sentence that was later reduced, commuted, or otherwise resolved favorably, only to have DOJ file a brand new denaturalization complaint months or even years afterward, built on that exact same underlying conduct from the original case. In other words, resolving a criminal matter in the past, even successfully, and even with a favorable outcome on the criminal side, does not mean the immigration consequences tied to that same conduct are permanently closed or off the table. It's also worth understanding exactly what these denaturalization cases legally hinge on, because it comes down to one specific recurring detail that shows up over and over again. During the naturalization interview, every applicant is asked, under oath, whether they have ever committed a crime for which they were not arrested, and this question is worded very broadly. It's not just asking about crimes you were convicted of, or even crimes you were arrested for. It's asking about any crime, period, arrested or not, ever. A truthful answer to that question matters enormously, because a significant number of these recent denaturalization cases center specifically on situations where federal prosecutors allege the person answered that particular question falsely, concealing conduct that, had it been disclosed honestly, could have affected their eligibility for citizenship in the first place, or at minimum, would have triggered a much closer review of their application. This is exactly why immigration attorneys consistently and repeatedly stress that during the naturalization process, full and honest disclosure, even of minor incidents, even of things that happened decades earlier, even of things you were never formally charged with, is absolutely critical. Concealment that gets discovered later, even much later, can become the entire legal basis for a denaturalization case, regardless of how long ago someone actually naturalized or how clean their record has been ever since. To be fair and balanced about this, it's also important to understand that denaturalization is not something that happens automatically, quickly, or without significant legal process. This isn't a situation where the government simply flags someone and their citizenship disappears. It requires the federal government to actually prove its case in federal court, and naturalized citizens facing these proceedings are entitled to full due process throughout that entire process. The U.S. Supreme Court has held, in long-standing precedent, that naturalized citizenship cannot be revoked without what's called clear, unequivocal, and convincing evidence. This is a notably high legal standard, meaningfully higher than what's typically required in most ordinary civil litigation, though still technically below the beyond a reasonable doubt standard used in criminal cases. These cases can be pursued by the government as either civil matters or, in some circumstances, criminal matters. And either way, they genuinely take real time, resources, and formal court proceedings to litigate to a conclusion. This is actually part of why, historically, these cases were used so sparingly. Building a case that meets this elevated evidentiary standard takes substantial investigative and legal work, which is exactly why the current administration's decision to dramatically scale up how many of these cases get filed represents such a significant shift in enforcement priorities and resource allocation. So, given all of this, what does it actually mean practically if you're a naturalized citizen watching this video right now? If you have any criminal history whatsoever, and I mean this broadly, including old arrests that never actually resulted in a conviction, past immigration violations of any kind, or really anything you may not have fully and completely disclosed during your original naturalization interview all those years ago, this is genuinely a moment to take that seriously, rather than simply assuming it's ancient history that no longer matters to anyone. This concern applies even if the underlying matter was fully resolved years ago, whether through a plea deal, a completed criminal sentence, a dismissal, or any other type of resolution. The absence of an ongoing legal problem in your criminal case does not automatically mean there's no exposure on the immigration side. It's also worth knowing, particularly for anyone who runs a business or manages a workforce that includes naturalized citizens, that if an employee faces denaturalization proceedings, the consequences can extend well beyond just that individual person, potentially affecting their work authorization and their overall immigration status entirely, which obviously has real implications for employers as well, not just the individual employee. If any part of what we've discussed today sounds like it could possibly describe your own situation, or honestly, even if you're simply unsure whether something from your past could ever become relevant in this kind of context, the right move is to consult with an experienced immigration attorney who can actually review your specific naturalization history in detail and assess your genuine level of exposure, rather than trying to guess your risk level based on a news headline or a video like this one. And if you happen to be currently going through the naturalization process yourself right now, this entire story serves as a strong, real-world reminder of just how seriously both USCIS and DOJ are currently treating the good moral character requirement and the honesty obligations built into that naturalization interview. This is not the moment to downplay or omit anything from your personal history, however minor it might seem. This is clearly not the end of this particular story, and it's almost certainly not the last batch of denaturalization cases we're going to see either. Given the administration's stated enforcement priorities, the documented jump in filings throughout 2026, and the broader trajectory we've seen since that June 2025 directive went out, denaturalization enforcement appears to be continuing to expand rather than slowing down. We're going to keep tracking this story closely, and we'll bring you updates as new cases, new patterns, and any significant court rulings emerge in this space. If this breakdown was helpful and gave you a clearer picture of what's actually happening here, subscribe to US Visa News Hub so you stay informed as this situation continues to develop. Thank you so much for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.